You have to steadfastly believe that you are going to succeed in what you're doing,
100%.
and you have to commit, and you have to do it every single day.
Yep.
Never stop. If you make a mistake, own it, fix it,
Mm.
and treat your clients like the most important thing in your world, because they are.
Welcome to Red Talk, the real estate development talk, your go-to podcast for insights, trends, and expert conversations in the world of real estate development. Stay tuned for engaging discussions with industry leaders and professionals who are shaping the future of real estate. If you are a developer, builder, or a general contractor, you are about to gain insight from someone who has not only walked in your shoe, but also mastered the legal landscape of construction. With over 8 years of hands-on experience in heavy civil construction and residential lot projects, he transitioned from being a general contractor to founding Vancouver's top-ranked construction law firm. His unique blend of practical construction knowledge and legal expertise has made him the trusted advisor in the industry. Please join me in welcoming our distinguished guest, Tim Sportschuetz. So Tim, welcome to the podcast. It's great to have you here. Now, a little bit about your journey, your career journey. What inspired you to transition from being a general contractor to founding a construction law firm?
So I worked in the excavation and the civil construction world for about 8 years prior to going back to law school. And during that time, I learned the civil construction side from the bottom up from my then boss. And we would frequently get into disputes or conflicts as they happen on site. So we would retain the services of specialized construction counsel, usually out of Vancouver. These lawyers I would meet, and then I would show them with drawings or our documents, our change order forms, our contracts, and I would paper for them the way we saw our position, our claim, and how to advance it the best way. And then usually what would happen is those lawyers with whom I dealt with, they would, say, hey, you're quite adept at this. Maybe you should think about going back to law school. You have this unique skill set.
Excellent.
So that's what I ended up doing. I studied for a very long time for the LSATs, the entrance exam for law school, and ended up moving my life down to Vancouver and went to UBC Law School, Allard Law School now. And once I graduated from law school, I worked for a smaller boutique law firm. I learned, the basics, contract drafting, the types of agreements that exist in the construction world. A little bit about litigation. My practice now focuses almost entirely on the solicitor side. So you have the lawyers that go to court, and then you have the lawyers that do drafting work. My practice is, I would say, 80 to 90% drafting. So I help developers with contracts, negotiation, pre-construction negotiation while the construction is going on, and any disputes that might arise after that don't involve court. So my three other associates, they do all litigation. So they go to court.
Okay.
Backing up, so I worked for a smaller boutique firm specializing in construction law, and after that firm, I articled there, and I worked there for about 6 months, and then I moved to a firm in downtown Vancouver as well, larger firm with about 55 lawyers or so.
Oh, wow.
And worked there for about 2 years, and then in May 2020, I decided to launch my own boutique construction law firm.
Excellent. Excellent. And how did your hands-on experience in construction shape your approach to practicing law?
So the hands-on experience is in my view priceless, and
100%.
it's irreplaceable.
Yes.
I pride myself and our practice and the way I assist team members, and I try to instill this in all of my team members and colleagues. We always approach the practice of law for every client not as just a file or a job. We look at it as a career, and we're fortunate enough to have a career. Many people don't have that, and we treat it with the highest level of professionalism.
Yeah.
We don't cut corners. We do an excellent job for every client, and that's our motto, I would say. As far as my background, it's really helpful because you'll get developer clients come in, or trade contractors, for example, bulk excavation contractors.
Yeah.
They'll come and see us, and immediately they're met with a crew that knows their business, because I have instilled some of my knowledge into my colleagues. And when I meet these clients initially, whether it's by phone or in person, I can talk their talk. I know what they're talking about. I know what they're experiencing. I know the issues they face on site. I'm not just the lawyer who went to law school but has absolutely no idea of what actually goes on site, or knows the site from doing it for years at a time, every single day, from 7 a.m. till 5 p.m.
Wow, yeah.
So
I think that's one of the unique things I found about you, that when we were researching lawyers, that you have the practical knowledge of construction, and you've been on that end, and now you're helping with that knowledge developers, builders, and contractors. That's, like I said, like you said, priceless. For sure. Now, what challenges did you face when transitioning from construction site to courtroom?
A lot. It's not easy. First of all, going back to school after working for 8 years is at least for me, it was extremely difficult.
Wow.
Because you start making some money, you're having that feeling that you're adept at something, you're good, and then leaving that life behind and starting from scratch is quite difficult. I was surrounded by really, really smart students. They were still, vast majority were still in that study mode, that professional university student mode.
Yes.
So going into that world as someone who worked for a living, it was very difficult. So once you learn the process of law school, I think it can get better. So after that, transitioning into the legal work world was actually a lot easier for me, I think, than a lot of my fellow students, because I think they were frankly transitioning into a full-time job is always more difficult, I think, if you've never had a job.
Yes.
So for me, starting in the work world was not a huge transition, because I'd been doing it for 8 years, and I'd been doing very long hours, and you kind of grow some thick skin in the construction world. So learning curve was steep, but not as steep as I think a lot of other lawyers experience, because I had that background. I was actually able to use my Rolodex of contacts in BC in the construction world, and I was able to call some engineers, consultants, or trades, and ask them questions about certain issues that we might face. I had this I was fortunate enough to have the ability to find the answers to questions at source from someone who knows what they're talking about. So that helped me a lot. And I had really good principals, principal lawyers, senior lawyers that were really excellent to me and taught me a lot. So
excellent.
Yeah.
And I have to commend you on your dedication,
Thank you.
to stop a career and then start a new one and actually go to school when you're not on school mode. I can totally relate to that.
Yes, it was very difficult.
It would have been, yes. So how has the construction landscape evolved in British Columbia over the years, in your view?
That's a really good question. I would say the one thing I noticed when I came up in the construction world, we did a lot of handshake deals. Mm-hmm. So we had a close group of material suppliers, other trades with whom we did business on a regular basis. And, if a change came up on site, frequently we would just shake hands on it and say, okay, let's lump sum 20 grand. That's fine. And it was honored at that time. Now I find that world has essentially disappeared. And I hear it from a lot of old school guys still that world has evaporated. Mm-hmm. It doesn't exist to that degree anymore, if at all. You don't make handshake deals. No. Everything has become much more litigious.
Yes.
Don't get me wrong, it still exists, but much less so. So I think people approach the business of construction in a much more corporate way, more careful as far as contractual terms and conditions are concerned.
Yes.
Whereas, when I worked in construction, there were oftentimes multi-million-dollar decisions made via handshake.
Yes. And the prime example is the contract I shared with you, that between friends, what we had done. And it's such a mistake that, and if I knew you at that time, I would have actually passed on the contract to you and get you to redo the contract for me on my behalf, right? But
I see this frequently. So when clients approach us, some of them know what lawyers cost. It's not cheap. It can get very expensive very quickly. So we know that, and we're alive to that issue because a lot of people it becomes quite prohibitive.
Yes.
Having said that, a lot of clients also appreciate what we can offer because they will spend, I don't know, $3, $4, $5 grand up front on a larger project that might be worth $20 million or beyond, or it might be worth a $2 million detached home build, whatever it might be. It's a quite relatively small number to have a contract reviewed because you might save yourself a $300, $400, $500 grand dispute down the road.
100%. Yeah. I think in my case, we have already lost at least 50 to 60,000, and I would have paid $5 grand, no problems, right?
Yeah.
So these next set of questions are more geared towards like leadership and kind of business skill sets that you have developed over the years, right? So what was the biggest challenge in founding and growing Vancouver's top-ranked construction law firm?
I think starting off, starting your own law firm is quite difficult. Not the mechanics of it. You, as a lawyer, you're fortunate because you have a license and you're protected by licensure. Not anyone can just jump into the legal field and say, hey, I'm a lawyer now.
Yeah.
So we have that inherent protection in this industry. Having said that, to start a firm and then actually grow it are two entirely separate things. A lot of people can go out on their own and work 3-4 hours a day and be happy with that approach and make enough money to provide a good living to their families. But starting a small law firm and when you came from a larger law firm, oftentimes you're also looked down upon. So there's a credibility issue.
Yeah.
Who is this guy? Single lawyer, sole proprietor, like deal with our large law firm instead.
Yeah.
So there's always that. And if you as a founder cannot overcome that, that inherent, I would say insecurity, then you're going to fail. You have to steadfastly believe that you are going to succeed in what you're doing,
100%.
and you have to commit, and you have to do it every single day.
Yep.
Never stop. If you make a mistake, own it, fix it, and treat your clients like the most important thing in your world, because they are.
That's right. That's right.
Yeah.
Great advice. Great advice. And how do you balance being a lawyer and an entrepreneur running a law firm?
I quite enjoy it.
Yeah.
I quite enjoy it. I love the business side of law. I sometimes help teach in a course at UBC Law called The Business of Law.
Excellent.
With a good friend of mine, Guile Clark. He's also a law firm founder, very successful. And Guile has asked me on several occasions to come help with this course he teaches at UBC Law, to help out with these shorter sessions with students who create these law firm profiles and act out launching a firm. So the business side of it is actually fascinating.
Yes.
Lawyers and several other professionals, but I would argue probably lawyers have the highest net profit ratio out of any professional that I could think of. Maybe some very specialized surgeons, but lawyers can do quite well if you structure your business well. But it takes a tremendous amount of commitment, effort, and attention to detail. You can literally fail overnight if you don't pay attention to details. And I think that's the main problem a lot of lawyers have. They're very good at practice.
Yes.
But once it comes to the business side, they either put their head in the sand or they're not good at it.
Yes.
I thrive in that environment, and I welcome it. If I'm not working 10, 11, 12 hours a day, I often get anxiety thinking, I'm not needed anymore. And it's quite difficult for me to deal with, but
I can relate to that. Like being a realtor for 20 years, same thing. If I don't put in so much work in terms of prospecting, in terms of calling past clients, it just feels like I haven't accomplished enough.
Yeah.
Right. Yeah. So I can totally relate to that. Now, my son actually is thinking about law, and he's debating, should he do law or should he do accounting? So I'm kind of pushing him towards law.
He'll make a lot. He will likely make a lot more money in law if that's what he's interested in.
Yeah.
Accounting is a great profession as well.
Yes.
I work with some great accountants.
Yeah.
So I like both professions a lot.
Yes.
But he needs to study the ROI on those degrees for sure.
Correct.
Yeah.
Correct. So what advice would you give young professionals aspiring to build a career in construction law?
I think find a law firm and then attach yourself to a principal lawyer that actually knows the industry, and just learn everything that you can in the first 3, 4, 5 years.
Yeah.
Pay extreme attention to detail. Don't focus on the money right away. Think long term, because the money will come.
Yeah.
Become extremely good at what you do. Be a hedgehog. Don't do a million things half decent.
Yes.
Do one thing extremely well. That's, I think, the one and only advice that matters. And then show up and do it every single day.
Yeah.
Don't be lazy.
Yes. And
work your ass off. Yeah.
Great advice. Great advice. Now, the next set of questions I think our developers, builders, and general contractors will benefit from. What are the most common legal mistakes contractors make, and how can they avoid them?
I would say that's a very broad question. I think one is not having a written contract in this world.
Yes.
Like I said earlier, things have become quite litigious.
Yeah.
Either they have a verbal agreement, and we as lawyers have to backtrack based on their conduct and comments, emails, text messages, WhatsApp groups, what the terms were. It's quite
Wow.
difficult on an evidentiary basis.
Yeah.
I would say that happens a lot, or they come to us with a badly drafted written contract, which doesn't help us very much after the fact, after the dispute has arisen. So I think that's a key issue. I think another one is a lot of people just don't know, even when they have a great contract, a lot of people don't read it or they don't understand it. That's very risky. They don't know what their rights are, what their obligations are under the agreement, what their risks are.
Yeah.
So a lot of contractors just are not paying enough attention to the risk premiums they should be putting on a contract or the supplementary conditions. I've seen some horrendous supplementary conditions that allocate the risk in such a way that it makes performance of the contract for a GC or a trade almost impossible. And there's just an inherent unfairness from day one for such an agreement.
Yeah.
And that's fine. Take that on. But then, especially if you're bonded on that project, which, requires a general security over all your personal assets as a director of that company. It's a very scary thing to be bonded and provide a bond.
Yeah.
So if it's bonded or if there's risk, you need to throw a dart at your bid price and say, look, we need to aim higher. So throw maybe a 20% premium on it. But most contractors still go in very tight. And I think that's a mistake. I think a lot of people just aren't paying attention enough to the contractual risk allocation.
Yeah. And a person like you would draft and review their contract, whatever the contract they have, but also draft a contract specific to their needs.
Yes,
I guess,
absolutely.
right?
Absolutely.
Yeah. Now, can you explain the importance of the builder's lien in protecting the interests of contractors and owners?
Yeah, so the Builders Lien Act is a statutory creature. So that means we have the common law, which is judge-made law. So, the previous judge makes a decision based on the factual circumstances of a case, and assuming there's no statutory underlying regime, the judge will make a decision based on what he or she thinks is appropriate.
Yes.
The next judge then, on a similar set of circumstances, might pick up that judge's decision and rely on it because they're bound by it if it's the same court level.
Yes.
Or the level above it, or it's an interesting decision and it's very convincing to that judge. Then we have statutory creatures, which are the Builders Lien Act, the Strata Property Act, our revenue codes or tax codes, criminal codes. Those are written statutes. And what happened was when contractors or trades or material suppliers would provide work to a project, and they were owed money, they used to have to sue for breach of contract for failure to pay. So that's a great recourse. We're fortunate to have this legal system in British Columbia. But the issue is you oftentimes end up with nothing if the owner is judgment proof, no longer going concern, or you don't have the funds to bankroll a multi-year lawsuit, which can get very expensive.
Yeah.
And then litigation is inherently risky and uncertain, so you don't know the outcome oftentimes.
Yeah.
So the Builders Lien Act came into being because it provided a statutory method of protecting your unpaid accounts by giving you what we call an in rem. There's in rem and in personam. In personam is a contractual breach claim. In rem is a right against an underlying piece of land or property.
Okay.
So the statute, the Builders Lien Act, gave trades and suppliers the right to file a charge against that piece of land to secure their unpaid accounts. It's a very, very powerful tool because when you file a charge against a registered title, that title becomes untransferable. You will no longer be able to mortgage it subject to certain provisions in the act where you can allow priority precedence to an existing lender, but that gets quite complicated. In other words, if you file a lien against, for example, my piece of land, I can no longer transfer it to another buyer. If I approach any lender to provide me a HELOC or a mortgage, a second mortgage, they will not even look at it until I remove that lien.
Yes.
So it's a very, very powerful tool that's protected by statute. They had to bring it in by statute because the common law doesn't grant someone that right.
Wow.
You see.
Yeah. So it wasn't there before.
No.
Wow. Okay. And so with builder's lien, you have a certain time frame to file.
Yes.
Right.
Yeah.
So from
strict
the
time frames.
occupancy, is it from the occupancy permit?
No. So occupancy has, a lot of people think occupancy has an important role in it. It's an indicia, but it's not. By no means be convinced that occupancy date is the date your lien filing period or holdback period is triggered. It's not.
Wow.
It's something that you can look at to consider whether the lien filing period has commenced, but the Act doesn't even mention occupancy. So the Act has very clear deadlines. So there's two time periods that most lien claimants and owners should be aware of. There's 45 calendar days and 55 calendar days.
Yes.
So you can file a lien generally 45 calendar days if there's a certificate of completion issued.
Yes.
Either your contract or the contract above you. So if you're a subcontractor and the general contractor's agreement is certified complete, that triggers also your 45-day deadline to file a lien. So anyone underneath it in the construction pyramid.
Okay.
If there is no certificate of completion issued, which happens all the time, you have to go to the next section within the Lien Act, which says the head contract is completed, abandoned, or terminated. If there is a head contract. So head contract is further defined. It says that there's a single contractor to do the majority of the work. Oftentimes, as you know from building yourself, the owner will engage trade contractors directly. They don't use the GC model.
Correct.
So if that's the case, there is no quote unquote head contractor. So now we have to consider the improvement completion approach under the Lien Act, which gets even more complicated. It states that the improvement is ready for use or is being used for its intended purpose. Wow. So it's an extremely misunderstood provision.
Yeah.
People get it wrong all the time because they'll come to us and say, we're fine. The occupancy was just issued 10 days ago.
Yeah.
In fact, you missed your lien filing period by 60 days already because it was certified complete, in November.
Yes.
For example.
Yeah.
So if you are unpaid and seek legal advice immediately. Don't wait because you need to protect your accounts.
100%.
Yeah.
Wow. So this is good because I'm learning quite a bit from you here.
Good.
Yeah. So what role does mediation and arbitration play in resolving construction disputes, and when should it be considered?
So almost all contracts have or should have a dispute resolution term. If you don't have that, I would say it's a quite significant oversight because you are essentially left with pursuing your debt or dispute via the public courts. We've had an unfortunate development in BC, and I think Canada-wide, just with the shortage of judges. And our legal system is clogged. Like we can't get in front of judges on time. We can't often reserve enough courtroom time to be heard. A lot of these trials require 10, 15, 20, 30 days of trial time. Trials will book 2, 3, 4 years out, and then oftentimes get pushed because certain judges are moving, or there's
Yes.
less judges, or they can't find replacement judges.
Yeah.
So what we've seen is a significant uptick in alternative dispute resolution, which means private mediation or private arbitration. So mediation is non-binding. You generally find a mediator who's most often an ex-judge or a very well-respected senior ex-lawyer in the industry. And you will schedule a mediation with the other counterparty, and you will meet and discuss your disputes and your side of the story. And you usually prepare mediation reports. So you set out your facts and your view of the law. And you present this in front of a mediator who's an objective third party. And the mediator will jointly generally listen to a session of mediation and then break out the groups into breakout rooms and try to coach them along and introduce for them the potential risks if they were to go to litigation, the downsides, the costs,
Yes.
the stress involved in litigation. And oftentimes they end up settling or settle shortly after a mediation.
Yes.
The problem is the mediator has no authority to make a binding finding on the parties. So if you don't settle, that's it. You pay your mediator bill. It's private,
Yeah.
and you move along. Arbitration is an excellent tool. It's binding. It's a similar story to a lot of mediators will also arbitrate. So an arbitrator is also senior ex-lawyer or judge.
Yeah.
It's private. It generally, you can be heard within weeks, if not, a couple months at worst, if you really want to push it along.
Okay.
So you have that ready access to it. It's generally quicker. It's not often cheaper, actually. A lot of people might think arbitration is cheaper than litigation in the open courts, but it's often not, because you end up having to pay not only your legal costs, you often have awards for full indemnity costs of the other party if you lose, so you have to pay their legal costs. And then oftentimes the losing party also has to pay the entire arbitrator bill, which, can run $5 to $10 a day on top of everything else. Wow. So it can get very costly, but this is also a great leverage tool, because if you have a strong claim, the other party needs to think very, very carefully whether they want to actually proceed to arbitration, because the downside risks can be severe.
Wow. So I can see how this is kind of a niche, like family law is, and criminal law is, like construction law is huge. I think there's so many aspects like you have to think of, and it's just coming out as I speak with you. It's mind-boggling. Now, how do changes in building codes and regulations impact the legal disputes in construction?
We generally rely on very particular building code disputes or a dispute over drawings and which drawing might take priority, for example, architectural versus structural drawings. We don't have the capacity as counsel to provide opinion evidence on any of those issues. So what we always do is rely on either in-house experts to provide us with counsel in the background for our client, or we rely on public court experts whom we hire, and then they will either draft the report for us, which we tender into evidence in the court, or they provide, they might be cross-examined as well on their report. So they would have to be a witness and speak to their report and their supporting evidence. So changes in the building code would be certainly something where you would want to have a code specialist comment on those and how they impacted the project at the time. Now, if you're constructing a project in 2020, the codes at that time would be applicable.
Yeah.
So if the codes changed during the project, we'd have to explore how that would affect it, but likely there's no issue to it because you're still bound by the previous code. The one that they issued the BP under, the building permit under.
Okay. And what emerging trends in construction law should industry professionals be aware of?
Right now, a lot of the VRCA and the BCCA and the CCA, well, CCA less so because they're on the federal level, but the provincial construction associations are generally very much in favor of pushing and lobbying the government to introduce prompt payment legislation. So several provinces in Canada have prompt payment. Federally, there's prompt payment. Prompt payment is something that would very likely be combined with our existing Builders Lien Act. That's how they did it in Ontario and in Alberta. And what prompt payment can do in most circumstances is provide an interlocutory way for parties during a project to say, my invoice has gone unpaid, it's late, and it gives them certain rights to immediately find essentially a mediator to consult, and the mediator will give a very quick decision as to what is owed, if anything, and it gives the parties a right to immediately get recourse under this prompt payment regime. We don't have it yet in BC.
Why not?
I don't know. I don't know. I've had plenty of panels where I was with significant industry leaders, very influential people in the industry, and we've had discussions with government representatives, and I think it's just not on the current government's radar for who knows, several reasons. I'm sure they have enough problems that they have to overcome, and maybe they're looking at the construction world right now and saying, look, we can get to this maybe down the road. Right now, we have other fires to put out.
Wow. Hopefully this comes in because it will make it so much simpler.
Yes,
right?
I agree.
Yeah. Now, what advice would you give contractors and developers to minimize the legal risks during the project? Because all the things we have just talked about, there's so much to know, right? And how do they minimize risk?
I think contracts again.
Yes.
Have your contracts reviewed.
Okay.
Have the supplementary conditions reviewed. Have the schedule reviewed. Have the schedule be realistic. Consider whether there's any liquidated damages, delay clauses. I had a client recently come to me who's a very smart businessman, runs a very large mechanical outfit. And he smartly asked me, hey, can you guys draft for me language around potential tariffs coming in, right? The Trump tariffs.
Right.
It was really brilliant. I wish all clients did this, but, that's why some succeed and some go broke.
Yes.
Now it's something where we always raise that for clients. Hey, this is a risk. We've prepared this additional term for you, included in all future contracts until we know what might happen.
Yes.
So you can really allocate a lot of the risks through properly drafted and thought out contracts.
Yeah.
Staff training. I do a lot of staff training with a lot of larger contractors and developers where I meet their senior representatives, C-suite people, and I explain to them how the Lien Act works, how you can protect yourself from registration of a lien. I discuss with them on-site issues, how to protect yourself, change orders, how to deal with those proactively. There's several more ways you can do it. I mean, there's insurance, there's bonding, but I think one of the key features is, of course, the contract.
Yes.
And I think, like I said before, unfortunately, many people just don't even read it.
A lot of people just download one of those kits.
Yes.
Right?
Yeah.
And a lot of people miss out the kind of terms and additional supplementary terms that you're talking about, because that would, and people try to save like 5-10 grand. And what that does is in the long run, it can cost them 50, 60,000.
Yes.
Right?
That's a cheap claim.
Yes. Yes.
Yeah, that's a very
or even higher
low cost dispute. Yeah.
Yeah. So it's always wise to, I guess, spend this much money up front and have yourself protected in a big way, right?
I think so.
Yeah, 100%.
I think so. We certainly did so when I was a contractor, especially during the later years, because I saw the writing on the wall with a lot more litigation happening. So I think the younger generation is less handshake. I find that frankly sad. In my view, because I thought that was a beautiful feature of the construction world or any business world where you can shake hands and the person shaking your hand stands by their word.
Yes.
But, that counterparty risk you can't overcome any longer other than contract.
Yeah. I think having those terms and outlined on a piece of paper is much needed now.
For sure.
Because it only takes that one thing to happen, and now you are totally in a mess.
That's it.
Right? So I guess the next round of questions are not so much legal heavy. They're lightning round and fun round.
Yeah.
So I'll just ask you some fun questions so people can get to know you, like your personal side. So are you a coffee person or a tea person?
Coffee.
Coffee?
Yeah.
Okay. Are you a morning person or night owl?
Morning, since years. My construction boss drilled that into me. I get up every day at 4:45.
Good for you.
And then I'm in bed by 9.
Oh, wow. Discipline.
Yeah.
And what's your favorite vacation spot?
I'm German, so I trend towards Europe. I really love Salzburg.
Yes.
And Munich.
Nice.
Yeah.
Nice. Go to comfort food.
Pizza.
Pizza. Same. Favorite book or movie?
Anything Churchill. So the Second World War by Winston Churchill. I think should be required reading for every young kid.
Nice. Okay. And beach or mountains?
I'd say mountains.
Okay.
Yeah.
And favorite season of the year?
I'd say spring.
Okay. And what's your favorite hobby outside of work?
I think spending time with my little daughter. She's
Nice.
11 months, so almost a year now. So
I bet. That's great. If you could have dinner with any historical figure, who would it be?
Winston Churchill, for
Winston
sure.
Churchill.
No question.
Okay. And what's your hidden talent?
I would say kiteboarding. Yeah, kiteboarding.
Kiteboarding.
Yeah.
Wow.
Yeah.
Excellent. Thank you so much, Tim, for sharing your valuable insights today. To our listeners, don't forget to subscribe to our podcast to stay up to date on future episodes. We have more engaging conversations lined up that you won't want to miss. Thank you so much for listening. And until next time, stay informed and stay inspired.